This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hello, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the Menendez Brothers retrial. First trial ended in a mistrial. We streamed that video, which was available by video. This trial, there was no video, so we are reading through the transcript from start to finish. We are on the defense's case, and Erik Menendez is currently on the stand. We are about to finish up direct examination. So that is going to be our first. That is what we're talking about today. It's going to be the very tail end of Erik Menendez's um, direct examination, and then cross will begin in the next episode. I'm going to try to get to the very end of direct in this video, but it that means it's going to be a little bit longer of a video. I'm going to try to squeeze it all in. As I've said on other videos you might not have heard yet, we just recently got a puppy. He's down here. So story on that real quick. So if you've been following my channel or have watched older videos recently, I've talked a little bit about my dogs. Mainly the one that always wants the blanket. She's still here and alive and kicking and doing well. But the other two dogs that I had were German Shepherds and Dexter and Abby. And I have the largest holes in my heart in the shape of German Shepherds that I'll never, ever replace or get back. And I'm utterly crushed, to say the very least, about losing both of them. I lost them both like within 34 days of one another. They were my babies. I had them for 12, 13, 12 years. Um, it's been rough on me. So we recently, the house has been quieter, emptier. So we recently got a puppy. Plus, the other dog, Hazel, has been kind of depressed. So, or at least we thought so. So my boyfriend and I got a puppy this past weekend. His name is DOG, spelled capital D E E, capital O, capital Gee. I did not name him. This was the one condition my boyfriend had, was that he was going to name his future dog DOG. And this is DOG. Well, he's sleeping right now next to me, so that is why I'm recording. This might be in spurts as I get to record, so I'm going to shut my yapper and get started because I want to get through this. Hold on one second. All right. We are all set. So let us get started here. We're going to pick right back up where we left off, which was December 14th, 1995. And sorry, just shook the whole thing here. I'm trying to not wake the dog. Um, so we are coming back from our morning break, and direct examination resumes with Erik Menendez. So the court says, okay, everyone is present. Let's have the jury out. The jury enters. The court says, let's resume with direct examination. Mr. Levin says, Mr. Menendez, I'm going to play a portion of the conversation from December 11th, then ask you a few questions. That is the Dr. Oziel um, uh, conversation, recorded confession or whatever, in his psychiatrist Oziel's office. Mr. Levin says, is that the voice of Dr. Oziel? Yes, after the portion is played. And then another portion is played. Mr. Levin says, did you hear that passage, Mr. Menendez? Yes. Did you tell Dr. Oziel that your parents were ruthless? No. Was that his term? From knowing my parents, he came to his own conclusions. Well, did you tell him that you were also like an automation? He said, automation. auto automaton? No, I don't know what that means. Okay, well, that was confusing. Mr. Menendez, was that your voice on the tape? Yes. Was that your voice saying, I don't like hearing it? Yes. What was it that you didn't want to hear? Dr. Oziel describing my father in this way, him saying these things about him that, whether true or not, I didn't want to hear. I didn't like hearing. And by this point on the tape, they had talked for so long that I just didn't like hearing it. Now, the things that Dr. Oziel was saying about your father and your mother, were they true? Some of them, some of the things were true. Why didn't you want to hear them? Because, I mean, I had such horrible guilt over what I had done and didn't go there to start talking badly about my father and listening all the bad things that he had done. I just wanted to deal with the pain that I had and didn't want to hear him say that they deserved to die or we were somehow justified because of the bad things that they had done. And that's what was I felt was being said, and I didn't want to talk about these things, and I had told him that before. Wow. So he didn't even want to feel comforted to know that, his parents were not good people. He didn't even want any kind of comfort in that sense that maybe his parents maybe deserved it or it's not such a bad thing that they're gone. He didn't want that to hear that. Mr. Levin plays another portion and then he asks, Mr. Menendez, again, is that your voice? Yes. You indicated to Dr. Oziel you didn't want to hear anything about them. It doesn't matter what they were or what they actually were, whether it was a fantasy or it wasn't. What did you mean by that? Whether the things that Dr. Oziel was saying were true or not didn't make a difference in my mind. I loved my parents and I didn't want to hear the things. You stated several times I had no choice. I would have taken any other choice. I regret it. I may have had a choice. I regret it now. What did you mean by that? Just that, what I was saying before about they did these bad things, therefore they deserve to die, and it just wasn't true. And I was starting to cry and I didn't want to tell them the truth, but I didn't want him to think that these things I couldn't let him think that these things were true. I don't know why. I was opening up to that point, but there was just a lot of guilt and I just was broken down to the point where I couldn't take it anymore and I couldn't hear these things anymore, and that's why I said that. At the time you killed your mother and father, did you feel that you had a choice? No. Sorry, I need a drink there. Um, Another portion of the tape is played, and the witness says, I can't understand what's being said. And Mr. Levin says, I'm sorry. Erik says, I can't understand what's being said on the tape. All right, I can read it from the transcript if it's unclear. It's as clear as we have it. The portion is played. Mr. Levin says, Mr. Menendez, is that you talking to Dr. Oziel? Yes. You indicated in this conversation that something about it was a misconception in the family and no one else. A misconception in the family and no one else. What did you mean by that? Just that no one, my family worked behind closed doors that no one knew what was the family was really like and the image was all a misconception. You mentioned something about it was always take you and somebody would be yelling and screaming. It was always taking place downstairs. What were you talking about there? The fighting, the hitting. You mentioned the finding blood on the bed. What were you referring to there? Finding blood on my mom's pillow or on the sheets, different places. You mentioned you hate him for that. You love him. It was something, uh, wait. You mentioned that you hate him for that. You love him. It was something that was beyond control. Then Dr. Oziel asked you what was beyond control that you had to kill them. You said, eventually it had to happen. It was basically ruining my life. What were you referring to? The sex between Dad and I. I just have a little more of that tape I'd like to play. Mr. Levin says, is that your voice? And Dr. Oziel, Mr. Menendez, yes. Did Dr. Oziel say to you that your mother had called him? Yes. And did he tell you that she called and told him about your dad disinheriting you? That is what he said on the tape. Did he also say that because your mother said because he didn't like how you were behaving and he thought you weren't being respectful enough, but that your father couldn't tell you why? Right. And Dr. Oziel indicated that he told you what your mother had communicated to him. Did Dr. Oziel on a previous occasion tell you that? Yes. You indicated in this portion of the conversation that you couldn't get closer to either of your parents. What made you mean that? Or what did you mean by that? Never had there been bridge of communication. I think I said that we keep it inside and that's what we were taught to do. So like you keep the secrets inside the family. You don't talk about your problems or the issues. Your feelings, how you feel about each other and your emotions, you don't express. Did you talk to Oziel about the inheritance, the money that we now knew that you were going to receive? Yes. And did he tell you on the tape that he understood that you had problems because you did not want anything to do with the money? I need to see what you're looking at. Pardon me? I need to see what you're looking at. As I'm queuing up the tape, I'll show you page 29 of the transcript and ask you to look at the yellow portion. Yes. Now, do you remember a portion of the conversation with Dr. Oziel where you talked about the money? Yes. And was Dr. Oziel talking to you? He was talking to my brother and I at that point. And what was it that he told you that he understood with respect to the money and how you would deal with it? He was just relaying to my brother that I had told him before that I had a lot of problems with the fact that I was inheriting this money and that I wasn't sure that I wanted anything to do with it and that it made me feel even more guilty. The fact that I was getting the money, he was just telling that to Lyle. No, Mr. Menendez, following this discussion, but I want to back up a second. Something popped into my mind about the money. Oh, about Dr. Oziel. If you recall from the first trial, Dr. Oziel, I think it came up in this one too. Dr. Oziel tried to go into business ventures with the brothers, trying to get them to invest in his businesses, like all these different side businesses that he had, aside from being a therapist. Huh? Why is he a good businessman? How do we know that any of his businesses were good? But he tried to make it or to take it upon himself to be the financial advisor to them. So I just wanted to bring that up when because that popped into my mind when I was reading that. Now, Mr. Menendez, following this discussion in December, jumping forward a few months later in March, March 11th of 1988, I'm sorry, March 11th of 1999, you voluntarily surrendered yourself to the authorities concerning this case, did you not? Yes. And you've testified to you being in Israel and receiving information and returning, correct? Right. And following your return to Los Angeles and being arrested, you were taken to the Los Angeles County Jail? Yes. And that's where you remained continuously since then till now, March of 1990. At some point in time, did you make a decision to talk to someone about the fact that your father had sexually brutalized you for 12 years? I, yes. When was it that you made that decision? In April or May of 1990 is when I first decided that I wanted to tell people these things. And prior to that, so this is the spring after the murders happened. So the murders took place August 20th, 1989. So this is May of 90. He's ready to like start talking about it to people. Prior to that, were you, or what was your state of mind with respect to revealing the fact that you had been molested? That I didn't want to say these things, that I didn't want to talk about my father this way, and even then I still didn't want to, but there was I felt such isolation and loneliness in jail, and I needed to get closer. I needed to find some love. Did you have any discussion with your brother concerning this issue? Yes. Approximately how many discussions did you have? At that time, many. Not so many discussions because yeah, not so many discussions because we had difficulty talking, but we would write to each other. And did Lyle Menendez tell you what he wanted to do with respect to revealing the fact that you had been molested? Yes. What did he tell you? That he would rather die or escape than reveal the molestation, that he and I now carry my dad's name and my dad's pride, and that we had already disappointed Dad once, and that to tell the world that we had done this and that the reason, and to talk about the sex, the molestation, would be to destroy Dad completely, and he worked very hard at convincing me not to. To whom did you first reveal that you had been sexually molested by your father? Objection calls for hearsay. The court says overruled. Witness says, Father Ken. When you say Father Ken, is he sitting in court today? Yes. Is that Father Ken Deasy, the priest in the second row to your left? Yes. Where was it that you confessed to him? As to, well, first of all, did you tell him? What did you tell him? I told him that. Objection calls for hearsay. Sustained. Did you tell him why you killed your parents? Objection calls for hearsay and irrelevant. Sustained. Following this revelation to Father Ken, did you tell other people? Either the same day or within the same group of days, I had been talking to Dr. Vickery. Dr. Vickery was um, a defense witness in the first trial. My brother wanted to tell my grandfather before we told any of the other relatives. So he started talking to his therapist. He was his therapist that was assigned to him after being in prison. But he was a good witness for the defense. Mr. Khan says, objection, non-responsive. The court says, after the name Vickery, everything else is non-responsive and is stricken. Mr. Levin, who did you tell? Or Mr. Levin says, sorry, I'm trying to readjust because the puppy's kind of up and moving. He's very floppy in his sleep, and he's kind of still half asleep and half awake. I'm giving him head rubs. All right. Sorry. Mr. Khan says, objection, non-responsive. The court says, after the name Vickery, everything else is stricken. Levin says, who did you tell? My grandmother, Aunt Joan, my Aunt Terry, Uncle Carlos, my Aunt Marta. Why did you tell them? They had a right to know. Who is Brian Eslamania? A friend of mine that had once been a friend of mine. So he's not a friend anymore. Was he a close friend? I don't know if he had been close. He was a friend. From high school? Yes. Did he visit you in jail? Yes. Did he visit your brother Lyle in jail? Yes. Did your brother mention to you at some point in time that Brian Eslamania could be a good witness for him? Objection calls for hearsay. Overruled. He, Lyle, was talking about how he would do anything not to have to talk about the molestation in the trial, and at one point he mentioned maybe Brian could help him avoid that. Did he tell you any specifics or details as to how? No. Did you respond to Lyle Menendez giving you that information? It was a very frustrating period between Lyle and I, him being so adamant about wanting to protect Dad in that way, and we weren't next to each other in the jail, so it was very difficult to talk to him much. I was very angry with him, frustrated and told him that it made no sense that he would have to do this, and it's not something he wanted to do, but there really was no other. Did you tell him to see someone? I asked Father Ken to talk to Lyle more. He started coming down every weekend. He said everyone deals with their past and pain at their own speed. Father Ken told me to give him some time and patience and he would eventually come to his own. Sounds like a good father. A good person to give a lost individual some advice. Did Lyle ever tell you that he was going to tell the truth and not use Brian Eslamania in the manner of whatever manner that he was? Several months later, we had a very heart to heart conversation, and he told me that he had decided to call Brian and tell him that he would be taking the stand. Now, in your first trial, which occurred back in 1993, this is 95, and it will complete in 96. Was Brian Eslamania ever considered as a witness for the defense? No. For the first trial. For the first trial, he was never. Um, You heard in court, did you not, the contents of Brian Eslamania's letter that your brother wrote to him? Yes. Was everything that was contained in that letter ever used in the defense in any way at any time concerning this case? No. So if you remember, in case you've forgotten, because there's so many details in this case, Lyle Menendez was trying to get Brian as Lamania to lie and say that Jose tried to molest him as well. He also was trying to get his ex-girlfriend, Jamie Pisarcik, to say that at the time as well to try to bolster their testimony in the second trial because they saw how the first trial ended in a mistrial and they didn't have enough to back up everything. Apparently, even though this is like the case when you think of cases with sexual molestation of children, usually you don't have as much evidence. You don't have evidence. This or there's little evidence to corroborate whether someone is my dog is snoring. I don't know if you can hear it. Um, Usually there's little evidence to corroborate that something happened. There's so much evidence. In this particular case, there is so much evidence. It's overwhelming how much evidence there is about SA. And yet they still weren't allowed that as a defense, as self-defense in the second trial. Um, Even though they said that they did it, I mean, they did it out of fear, and that is self-defense, but they weren't allowed to use self-defense as an excuse or as an argument, as a legal defense in the second trial. Was anything that was contained in that letter ever used in the defense in any way at any time concerning the case? No. Mr. Menendez, do you feel that you were justified in killing your parents? I was not. Were you in fear when you killed them? Yes. Why did you kill them? Because I thought that they were going to kill me. Why then don't you think that you were justified in killing them? Because they were my parents. There were no guns in that room, and I realize that now, and it was a horrible mistake. Mr. Khan says, Your Honor, can we ask the witness to speak up? I can't hear the witness speak. The witness says, It was an awful mistake, and I did the wrong thing. Mr. Levin says, Your Honor, I would like just a few moments to confer with the court and counsel at this time. The court says, okay, we'll take a break with the jury. We'll ask you to go to the jury room. The lawyers and I will talk about some matters. And when we're finished, hopefully before lunch hour, we'll have you come back. The jury exited the courtroom and the following proceedings were held. The court says, "You may return to counsel table." Okay, the jury has left. Mr. Levin says, "Your Honor, at this time, the defense has no further questions of Erik Menendez. Dependent upon the scope of the allowable cross, I would like to have the court at this time consider the motion that's been filed on behalf of Erik concerning and Lyle Menendez concerning whether or not the prosecution would be entitled to go into the Calabasas burglary juvenile adjudication regarding the confession by Craig Signorelli, which has not been gone into in the defense, and limitations that the defense feel are appropriate to be placed on the prosecution concerning Dr. Oziel's testimony from the prior, pardon me, as Abramson says, claims from the prior claims made during former testimony in which Erik Menendez has staunchly and consistently always denied being the BBC issue concerning the perfect crime issue concerning Dr. Oziel's murder slash manslaughter distinction. Those things have not been gone into on direct examination. So the Calabasas burglaries, just a reminder, back when they first moved to uh, California, I believe they were getting into some trouble, some mischief, and that included breaking into the homes of their friends' homes and stealing things. It was kind of like a thing that they did, um, like a contest to see who could get better scores or something. I don't know. That's what I'm assuming probably happened. But they did get caught, unfortunately, and had some criminal charges on them that they had to deal with, and Jose was not too happy with them. So that's the Calabasas burglaries that they're talking about. They were under the age of 18 at that time. And then the second thing that he's talking about, the BBC issue, the Billionaire Boys Club, which we haven't really talked about in this trial this time, but it was a big thing in the first trial. The Billionaire Boys Club was like a movie or something. It was like a made for TV movie about a boy killing his or a teenage male killing his parents or something along those lines, and they think that that had to do with, they were plotting and planning. When in reality, I think it was just like a made for TV movie that was popular at the time and it just happened to be around that time. I don't know. Anyways, and I think there's more to that, but I can't remember all the specific details. Anyways, so there's that. He says, I think I finished that. Um, oh, maybe not. Did I read this? Oh no, I didn't. Unless the prosecution is going to call Dr. Oziel, they should be precluded from going into these areas and making it appear that Erik Menendez said these things in the past when they know that they cannot prove them through any source. The court says, okay, let me first hear the prosecution's response to conducting this hearing now before the defense has completed its direct examination. Mr. Khan says, yes, at this time, I think that it's premature because the defense would make an election at this point concerning the areas in which they want to inquire into. And at this point, we would then make an election as to what we're going to cross-examine the defendant on. It's a strategical decision on the part of the prosecution depending upon the areas that the defense chooses to go into. And I don't think that they can have the court rule as to what the prosecution can and cannot get into, and then decide based upon that how they're going to present their defense, any more than we can ask the court to rule as to what is admissible in the defense and based upon those rulings, structure, or case in chief around that. So I would submit that it is simply premature for the court to make the ruling at this time. We frankly hadn't decided how many of these areas we're going to get into. Some of it may be necessary, some of it may be not necessary, depending upon answers given by the defendant. So I would ask that we not get into it at this time. When we reach the point where it appears we're getting close to some of the issues in here, perhaps I would raise the issue at this time or at that time and we could address it. So not obviously, but basically everything has been a fight with the prosecution here. And of course, they're going to fight it and say, no, you can't tell us what we can get into and what we can't get into, even though there are rules about what you can get into in your direct versus your cross versus your redirect. And I don't know all the rules, but I think he's trying to sidestep some rules here. So Mr. Levin says, Your Honor, that's precisely the purpose of 402 motions in limine to allow the court to make certain decisions in limine, and that's precisely what we're asking. The court indicated before that it could not make any findings or indicate any rulings until it heard the direct examination. I have now conducted what has been a direct examination, probably the mother of all direct examinations, over 7 court days. I wonder how long it's taken me to get through it. It's been a long one. It's been long. The court says it really hasn't been as long. It's over 7 days. We had a lot of half days in there. It really wasn't that. Miss Abrams says it's only the aunt of all. Mr. Levin says it's the great aunt because probably Ms. Ms. Abramson's first direct examination was the mother of all. So his is the great aunt, I would say. In any event, I have no further questions. The court can certainly make an issue or can make. Hold on. The dog is trying to get under the blanket, but she's not doing it. There you go. In any event, I have no further questions. The court can certainly make or issue a ruling with respect to many of these issues. Erik Menendez should be given the opportunity to explain the Calabasas burglaries if the court feels that there has been something that has been done that opened the door to them, but we feel that it would be unfair to allow the prosecution to, for the first time, ask the questions, and then the defense makes the objection, or we have to waste court time and approach the sidebar. There's nothing that's going to change with respect to the Calabasas burglary issue. Either the juvenile adjudication is admissible or it's not admissible, and we feel that the court, at least on that issue, should consider that at this time. The court says, all right, I've been thinking about that. Of all the matters that you raised, and really, that is the only one that relates to an issue that might well be dealt with before the defense has completed its direct examination. The reason why the Calabasas burglary came in during the first trial had to do with the relationship of the defendants to their father and the relationship of the defendants to Oziel, and certainly both of those issues are now before the jury. So he thinks that it probably could come in then. Maybe he's leaning towards that. There's a second matter as well, and that has to do with the contents of the December 11th tape. At the time that issue was addressed, the issue of the Calabasas burglary during the first trial, the court had not listened to that tape. The tape had not been played for the jury. It had not been ruled admissible at that point. There is reference on that tape to the incident and the disapproval of the father, and certainly a great deal of the defense has focused on the relationship of the father with the defendant, the testimony of the defendant on that subject, the way the father treated him, and the reasons for that treatment. So certainly that facet of the court's reason for ruling that matter admissible is heightened by the fact that the tape recording is now before the jury. Mr. Levin says, Your Honor, the people adduced that evidence over the defense objection. I understand that, says the court. Mr. Levin continues, Well, that doesn't make a prejudicial juvenile adjudication or conviction if it was admissible because the people, over the objection of the defense, laid the issue before the court. It's only when the defense adduces some relevant evidence by which the people can then attack if its credibility, if character witnesses are called, those kinds of traditional things offered by the defense. There's no law I'm aware of where the people can open up their own prejudicial evidence that the court says it's not a door being opened. It's a piece of evidence that's otherwise admissible, and it relates to this issue that we're now talking about, this Calabasas burglaries. Mr. Levin says, What evidence is there that the people can offer this court that would lead to the inferences that they wish the jury to deduce from the bringing in of this evidence? Nothing. All they can do, and the only reason they want to bring it in is to show that Erik Menendez and Lyle Menendez are bad people. It's bad character evidence. And the point is that you have the tape, number one, that shows Dr. Oziel saying on the tape that the father had disinherited Erik Menendez because he disapproved of him, because he was disrespectful, but couldn't tell Erik Menendez why. That's the first point. The second point is Carlos Baralt testified in this trial that Jose Menendez told him that he had disinherited them, but didn't tell Carlos Baralt why. There is no witness, there's no document, there is no evidence that the people can bring in this court, to bring to this court in any way to prove that which inference they wish to show the jury. That the dissension, the problems that Jose Menendez was having with Erik Menendez was based on the Calabasas burglary. They just don't have it. So they're trying to correlate the problems, the disinheriting, being related to the Calabasas incidents. After those happened, I guess maybe that was when Jose decided to disinherit them. I don't know. There really is no proof of that. Mr. Levin says, Mr. Levin continues, precisely. Even if they could, what is the relevance? There's no relevance to it, even if they could, but they don't have any proof of it. There's evidence that the father, the court says, proof of what? You're carrying on a conversation with Ms. Abramson, a continuation of the conversation. And I don't, Mr. Levin says, I think the argument that Ms. Abramson is cueing me in on has to do with the relevancy on that particular evidence coming in. Even if the people, hypothetically, had evidence that they could substantiate that that's why the father was or disapproved of Erik Menendez, what does it tend to show? What does it tend to add to the case? The prejudice is that Erik Menendez is a bad person, he's an evil person, that he has no credibility. I mean, the people want to destroy the entire credibility of Erik Menendez from a juvenile adjudication. That's precisely what the law has in mind when it tells the courts that they should consider very carefully before these issues are ever gone into, and that's the prejudicial impact that we seek to avoid. There is no law that would justify the people to bring in this juvenile adjudication other than the reference that is on the 1211 tape that they brought in, and that it is not mentioned on the tape about the Calabasas burglary. All it talks about is the Calabasas incident. It doesn't call it a burglary, which the jury can, if they are going to question what the Calabasas incident could possibly refer to. There's been testimony about the gang incident in Calabasas. There's nothing in this trial that is confusing about that particular innocuous passage contained in the tape. It is not gone into. It is not focused on by Dr. Oziel as a reason for any problems between the family and Erik and Lyle Menendez. It's not discussed in that context. Ms. Abramson says, Your Honor, could I be heard? Because I have a different factual knowledge than Mr. Levin. Certainly. Your Honor, the other thing is there's no indication that the conversation that Dr. Oziel related to Erik Menendez that he, Dr. Oziel, had with Mrs. Menendez concerning the father disinheriting happening at any time relevant to the burglaries. In fact, I think Dr. Oziel testified at the first trial that that was something Dr. Oziel, first of all, as the court knows, Dr. Oziel occurred in their lives after the burglaries were long over. But I believe Dr. Oziel testified that conversation with Mrs. Menendez was of May 1989, so that information about disinheriting is not chronologically linked to the burglaries, and it is linked to what Erik Menendez testified to in this trial and the last trial, that his failure to report his tennis practices, his failing to answer his father's questions at the dinner table, is what provoked this disinheriting or disavowing statement. So there is no factual linkage between the action by the father and the burglaries. But, Judge, even if there was, what's relevant about this? The fact is that the defendants were told that their father did or was going to disinherit them, not why. Why he was going to disinherit them has nothing whatsoever to do with has nothing to do whatsoever with whether they killed their parents for money. All of this is only relevant because the people have a motive theory based on money, which we are challenging by showing our client's state of mind that they would not benefit financially in the death of their parents. Okay. Moreover, the supposed Calabasas incident, incident that's mentioned on the December 11th tape, I mean, I cannot understand how, because the people chose to put in a piece of evidence that uses the word Calabasas, that somehow that gives them a right to explain what they think Lyle Menendez meant when he's the one who mentioned Calabasas thing on the tape, not Erik Menendez to begin with, and this is Erik Menendez's defense. When there is nothing that those burglaries tell us that advances any theory in this case other than the people's desire to attack Erik Menendez's credibility. Before I continue, just wow, I so miss out on her being the one asking the questions of Erik because she was so good in the first trial. But as you know, she was one of the doctors, one of the experts in the first trial, uh, al- accused her of like asking them to delete something or to not submit something with the report. And I don't know if that's true or not. I don't know the reasons, but because of all of that, she had to be kind of sitting down for this one and having her co-counsel Barry Levin do all the questioning because she made herself a witness apparently, and that's not allowed. All right. Let's continue on with whatever Miss Abramson was saying. And I would also remind this court that under the statement that the court was not allowing, quote, character assassination of the victims in this case, the court has not allowed us to put on the lying, the cheating, and the training at lying and cheating that these parents did, both with respect to their own affairs and in training their children. These were people that the court knows from the first trial lied routinely, particularly the mother, about everything, that told their children to lie and cheat and steal, but win. Uh-oh, puppy's up. Maybe we're okay. He moved to the edge of the couch by himself, but he's up, so I may have to take him out. Where was I? Right now he's just laying down. So both respect to their affairs and training of their children, these were people that the court knows from the first trial lied routinely, particularly the mother, about everything, that told their children to lie and cheat and steal, but win. So I don't understand the balance here. How a criminal defendant is allowed to be confronted with a burglary in juvenile court because that's what made him go to the therapist. So what? What difference does it make why he went to a therapist? All that is really relevant here is the tape recording he made with the therapist in December. Aw. You're looking for a warm, cozy spot. With the therapist in December. But somehow that's admissible. But the fact is, it's his parents who trained him to lie and cheat and steal is not somehow another facet to the relationship that would be illuminated by information. I mean, since the court is not allowing us to bring in who taught him how to lie and cheat and steal, I don't think that the people have a right to show that, particularly if it's for the inference that the court suggested. Hold on, don't eat the cord here. I need my earbuds. Don't pull that out or whatever. Here, eat your bone. I don't think that the people have a right to show that, particularly if it's for the inference that the court suggested because they participated in a burglary. That means their parents were shocked and offended. That gives the implication that their parents were moral, which we don't happen to believe is true or provable in this abstract or absolute. The inference is supposed to be these parents were so offended by the immorality of their children that they sent them to a therapist, when we know these parents were highly immoral themselves in many ways and totally dishonest in every way. So it seems to me that we're completely skewing the issues here by allowing in this juvenile burglary evidence when it does not prove any contention in this case and gives a false impression that my client is somehow a thief and dishonest while we've been permitted to show the dishonesty of the parents. She has. I I hear you, girl. Every single point you made, I'm back it up 100%. But the court says, okay, did you wish to be heard, Mr. Gessler? Mr. Gessler is the attorney for Lyle, one of them. Miss Towery is the other. Mr. Gessler says, well, I joined in everything that has been said concerning the witness, Erik Menendez, and also share some discomfort here that if that is gone into in any way concerning Erik, that it would come over onto Lyle as to one of those burglaries, as to certain facts, and I think there are different considerations involved here. So under 352, also, I think that the prejudicial effect on Lyle Menendez of getting into any of the burglaries on a theory against Erik Menendez would be prejudicial to this case. The court says, okay, let me hear the people's response. Ms. Abramson says, one other thing, Your Honor. Under 1101, there's supposed to be only certain exceptional circumstances where prior criminal activity of a defendant is admissible. And I don't see that these burglaries fit any of those stated exceptions. The court says, okay, people's response? Mr. Khan says, yes, once again, I think that the burglaries, evidence concerning the burglaries are just inextricably intertwined with a relationship between Jose Menendez and the defendants, as well as a relationship between Dr. Oziel and the defendants, critical to any evaluation of conversations that the defendants had with Dr. Oziel is going to be the very foundational issue of why they were there in the first place. It is inevitable that the defendants must be asked why they were sent or why they went to see Dr. Oziel so the jury can have some foundation upon which they can evaluate all this testimony. Why? They don't need to know why they went to Dr. Oziel's. I think the state is absolutely wrong, and the court is wrong if they bring this in. You can't conceal that piece of the puzzle. It's much too valuable and probative to simply hide it from them. And also, it goes to the relationship between the defendants and their father. Their father knew about the burglaries. There's no secret he was involved in the resolution of that matter. Yeah, exactly. He helped sweep it under the rug. That they obtained an attorney to assist them in the resolution of that matter, that an attorney represented them, was being paid by Jose Menendez to resolve the matter, and that was a major source of disappointment for Jose Menendez. I don't see how the defendant can stand up there and tell this jury, well, I have no idea why my father wanted to disinherit me. Maybe it had something to do with the fact that I wasn't playing tennis very well, when in fact we all know that Jose Menendez was upset about the burglaries, and this is something that ultimately led to the decision to disinherit them. I think it is simply too closely tied to the defendant's evidence as presented by them, even during this trial, that we simply can't ignore it and should be admitted. Ms. Abramson says the people have a very strange notion here that they have a right to inquire into conversations that Erik Menendez had when he first went to see Dr. Oziel concerning these burglaries. Any such conversations are privileged. Their privilege has always been maintained with respect to any such information. We reassert that privilege. He has a right to claim that privilege, the psychotherapist patient privilege, for anything he said to Dr. Oziel prior to October 31st, which is when he started confessing. The people have never sought uh, recognizing they could never prevail to go into those conversations, and they have absolutely no right to do so. So it isn't true that bringing in the burglary issue somehow spins off the conversations with Dr. Oziel, the conversation with Dr. Oziel, the contents of which has been gone into here, and only the ones that this court gotta go. The puppy is wants to go outside. Hold on. All right, I have been relieved of puppy duty, and I will back up because I don't remember exactly where I left off, and think I was in the middle of a sentence. So it isn't true that bringing in the burglary issue somehow spins off the conversations with Dr. Oziel. The conversations with Dr. Oziel, the contents of which has been gone into, are only the ones that this court and the California Supreme Court have ruled were not privileged. But anything that he said to anything that Erik Menendez said to Dr. Oziel prior to that is still confidential. We assert the privilege now. The people don't have a right to ask those questions when they know a privilege is going to be asserted on the witness stand, and that's just a fiction. with respect that that's that they have that right, and that's why the burglary should come in, because it has to do with prior conversations with Dr. Oziel. Moreover, for Mr. Khan to say we know Jose Menendez was disappointed with his sons because of the burglary. How do we know this? From the ether? There's no witness who has testified to this. In fact, what we know is that this family never told anybody about the burglaries and therefore never expressed to anybody disappointment with their sons about the burglaries because, like every other negative thing about this family, they hid it and kept it secret. So we don't have any idea why Jose Menendez was saying that he was going to disinherit his sons. The only idea that Erik had is what his father told him, and what we know is he didn't threaten to disinherit them because of burglaries. His anger over the burglaries was that they didn't get away with it. Let me repeat that. His anger over the burglaries was that they didn't get away with it. Not that they got caught, not that they did it, or that they, he's mad that they got caught, not that they did it. So there's a big distinction there. That they didn't do it smart enough. That was the kind of discussion he had with him about the burglaries. No moral judgment about stealing. So I think that we're proceeding here with a series of unprovable fictions on the part of the prosecution while ignoring an entire history of cases talking about the danger of allowing in prior criminal acts against a defendant unless it specifically fits an exception to the prohibition against doing so, and in order to eliminate the relationship between the people involved in the case. And there does not seem to be justification when this court has severely limited this kind of evidence that the defense is allowed to put in this case to totally illuminate the relationship between the defendants and the decedents by prohibiting us on the basis of remoteness or on the court's assessment of relevance from introducing all kinds of evidence that constitutes psychological maltreatment in the case or training, harsh and cruel training in this case. So to allow the people to reign, uh, to reign, to allow the people free reign to bring in prior criminal activity under the rubric of exploring the relationship and not to let us bring in treatment by the parents towards the defendants, is just utterly unfair. I don't disagree. Mr. Gessler says, Your Honor, unfortunately, my fears that I expressed earlier under 352 regarding the use of this, directly or indirectly against Lyle Menendez, have been brought to reality by the prosecutor's argument. Twice, he said, first, it's important as to why the defendants were there in the first place. The defendants were not there in the first place. Defendant Erik Menendez was there in the first place. Defendant Erik Menendez is the one who confessed to Dr. Oziel, and defendant Lyle Menendez only came on the scene after this had happened at the request of Dr. Oziel. He was not there concerning any burglaries by Erik or anyone else. And the second aspect was that he said that this shows the relationship between the defendants in the plural, and their father. In reality, the only passage that I can recall from this particular tape is at page 15, and it said, Lyle Menendez brought up the issue by saying, Oh, sure. He even told Erik that the Calabasas issue and the way that he handled it terribly. If he were in charge of it, he could have handled it way better than Erik. Now, this has nothing to do with saying he could have handled it better than us or handled it better than me or he could have done a better job. It's just again strictly between in that conversation Lyle Menendez relating his father's views towards Erik Menendez on this issue. So I'm very concerned now, having heard the people's argument, that that's exactly what they want to do, is to lump these particular incidents into proof against both Lyle and Erik Menendez, and I think unjustly so. The court says, what is the people's response? Number one, to the defense observation that the sessions with Dr. Oziel before October 31st are still privileged, and secondly, the objections of Lyle Menendez. Mr. Khan says, yes, well, I would submit that the sessions before are no longer privileged. The defense themselves, during their examination of this witness, asked the witness about the nature of the relationship between himself and Dr. Oziel. This is something they elicited. This is something that they brought out. Now that they brought that out, they're now taking the position that we cannot ask follow-up questions concerning the nature of that relationship. I think that is impossible to conduct cross examination into the nature of the relationship between Erik Menendez and Dr. Oziel in response to questions asked by the defense unless we are permitted to ask the defendant why he was there in the first place. It doesn't matter why you go to therapy in the first place. The jury cannot appropriately evaluate whether or not the allegations that he is making concerning that relationship and his feelings towards Dr. Oziel and the relationship of trust between them and the fact the relationship existed, they cannot decide this in a vacuum. The questions concerning Lyle Menendez, the people should be permitted at this point to inquire as to Lyle Menendez's presence at each of the sessions that were conducted. Really? That is the October 31st session and the November. The court says, I'm talking about the objection by Lyle Menendez, to references to any to any participation that he had in the burglaries in Calabasas. Mr. Khan says, well, I think that the burglaries are, in fact, relevant to establish the nature of the relationship between Jose Menendez and the defendants once again, and the nature of the relationship between Dr. Oziel and the defendants. Again, it's not Lyle is not does Lyle didn't have a relationship with Dr. Oziel. It was Erik who was seeing him. And just as Erik Menendez could be cross examined on any matter which happens to implicate Lyle Menendez, I could question him about the event that happened on Tuesday preceding the killing. And some of that is going to implicate Lyle Menendez. I can question him about events that happened on Wednesday and Thursday and Friday and all of those. The court says we're talking about references to another crime that has occurred several years before, a couple of years before, so we're not talking about evidence relating to this crime. Mr. Khan says, okay, well, the ultimate issue is, does it bear upon the facts of the case before the jury, and to what extent does it bear upon the facts of the case before the jury? Is it in fact relevant, and is Evidence Code Section 352 satisfied by that inquiry? And I would submit that it is relevant, and Evidence Code Section is satisfied because it explains to the jury the reasons why Jose was dissatisfied with his sons. We don't know that. It's my understanding from reading the transcript that the defendant, Lyle Menendez, was in fact involved in the burglaries. This is something that Erik Menendez testified to in the first trial, and this is something that the people should be able to bring out because it relates to the testimony of Erik Menendez. It is relevant to his testimony. It satisfies Evidence Code Section 350 and 352 as far as Erik Menendez is concerned. But it also satisfies Evidence Code Section 350 and 352 as far as Lyle Menendez is concerned because it relates to his relationship with his father, of which Erik Menendez had personal knowledge. So just because it relates to a prior crime, that is not a basis to exclude it. The evidence code specifically provides that evidence or evidence of prior misconduct is admissible unless it is offered solely to show propensity. Here we are not offering evidence of prior crimes for the purpose of showing propensity. We are not offering it to impeach Lyle Menendez. We are offering it only for the purpose of showing the relationship between Jose Menendez and Lyle Menendez. And it would tend to explain why Jose Menendez was so upset with Lyle Menendez and why he wanted to cut him out of the will. So, for that reason, I believe that 350 and 352 is satisfied and it is admissible against both defendants. Court says, okay. Any further response? Mr. Gessler says, we'll submit it. The court says, all right. First of all, as observed, the evidence did come in the first trial, so what we're doing now is listening to and evaluating the defense's objection to it. The defense position basically is that the court was wrong in the first trial, and secondly, that the circumstances are different this time around and that the issues are different. Therefore, the evidence shouldn't come in. Just some preliminary remarks. The court, first of all, is evaluating and weighing this offer of evidence under Section 352 of the Evidence Code and evaluating the probative value of the evidence against its potential for prejudice or for undue consumption of time or potential to confuse issues, as well as under Section 1101 of the Evidence Code, and there have been remarks made that the court has overly restricted the defense in its presentation of evidence of the character of the decedents in this case. And my response is that I'm reminded, really, of the lawyerly lament of what have you done for me in the last 5 minutes? Basically, because you haven't been listening carefully to the examination of Erik Menendez so far. If you think the court has limited the extent of or overly limited, or severely limited the extent of the negative evidence offered relating to the decedents in this case, there has been a substantial amount of evidence offered so far that has been presented, and the court has reviewed that offer of evidence on the basis of the probative value. After objections were made by the prosecution, the court permitted some of that evidence in over much of that evidence in over objection. And quite frankly, after the evidence was received, I had very great concern about the correctness of the decision because having heard the specific answer to some of the questions, it didn't meet the offer of proof as to why the evidence was offered as relevant. But it's there, it's been offered, and the court is satisfied that overall the rulings were correct and that the defense has quite adequately so far, and I'm sure there's more to come, the defense has been permitted to put on this evidence for a particular purpose. That purpose is to establish, if the defense can do so, a state of mind of actual fear at the time of the killing occurred. It was limited for that purpose, offered for that purpose. That was the reason for it being received. Normally, that evidence wouldn't be received in this trial, but for the fact that there was a particular purpose for it being received. And now we're talking about another particular piece of evidence that is being offered for a particular purpose. Normally, the defense is correct. Evidence of other crimes is not received and shouldn't be received unless there's a real good reason for it to be received. And that is what we've been hearing debated here as to whether or not there is really good reason why this evidence should be received. It was received, as I said, during the first trial, and when I talk about a really good reason, I'm talking about its probative value and then of weighing it against the potential for prejudice and potential to confuse the issues on this particular case. As far as the probative value, number one, as it did in the first trial, it does explain the nature of the relationship of the defendant and his father. Ms. Abramson says, how does the court says, I'm ruling right now, actually, not asking for any comment. Ms. Abramson says, I just wanted to. The court says, no, you're not. I'm just making my ruling. I'm making my ruling. And the ruling is that it tends to explain the relationship of the defendant and his father. The defense has sought to introduce a particular reason or motivation for that relationship, certain foundation for that relationship, and this certainly is a relevant part of that relationship and the father's reaction to it, as explained by Lyle Menendez and adopted by Erik Menendez on the December 11th tape, is relevant evidence that the jury has a right to evaluate in determining the credibility of Erik Menendez as to why his father felt the way he did about him. There is no evidence that correlates how Dr. Oziel or writing them out of the will relates to the burglaries. Absolutely no evidence. This ruling is completely wrong, in my opinion. But let's move on. Where was I? And as to why his father felt the way he did about him and why his father reacted the way he did to him, and various of the incidents that had been described, as well as the issue of disinheritance. The jury has a right to make that decision and not rely upon the oral arguments of counsel, but the evaluation of the totality of the evidence that will be presented. Also, the initial contact with Oziel, not the contact of communications with Oziel, but why it was that Oziel was seeing Erik Menendez. That was because of the probation grant in juvenile court as a result of the adjudication relating to the Calabasas burglary. Ms. Abramson says, that's inaccurate, Your Honor. That's not why it was. There was no probation grant requiring that he see. The court says it was certainly related to it. Ms. Abramson says he was referred. The court says the point of the overall evaluation, whether it was done prior to the court disposition hearing or subsequent to it, it was because of that, and to either support a presentation to the juvenile court in hopes of getting leniency or as part of the probationary grant. It certainly was intertwined with the juvenile adjudication. As far as the potential prejudice, yes, there is some prejudice involved in the jury hearing that the defendant had been involved in a burglary as a juvenile, but in the overall balancing of these matters, the court finds that the probative value of the evidence substantially outweighs any potential prejudice for, or confusion of issues as far, so he's letting this all in, which I think is totally unfair. As far as Lyle Menendez is concerned, his argument is that he hasn't taken the witness stand and he hasn't opened this up. The only way it's been opened up is through the testimony of the co-defendant explaining the relationship of the defendants to the father and also of the to the father, and also by the playing of the December 11th tape. That's evidence. That's evidence that's been received, and whether it was over the defense objection or not, it's evidence that is part of the overall picture here that would have to be explored during cross examination. This is something that the defense hasn't touched on in its direct examination of Erik Menendez so far in regards to the particular reference by Lyle Menendez adopted by Erik Menendez. Now, whether or not the defense had just intended to abandon that altogether, I don't know. Did you expect, Mr. Levin, that the people wouldn't ask any questions about that? Mr. Levin says, I'm sorry, Your Honor. The Calabasas reference, says the court. Mr. Levin says, yes, that was our belief. Our staunch belief was that the evidence was inadmissible. I think there's another prong to this. You're referring to the burglary, I take it. The court says the Calabasas reference. Ms. Abramson says, just a moment. Abramson and Levin confer. Mr. Levin says, I really didn't know what the people's intentions were concerning what is on the tape. It is not my client speaking, and I am unclear as to what Lyle Menendez was talking about, whether he was talking about the gang incident, when he was talking about his father's reaction, what that was that a combination of factors that included the fact that the father had been caught cheating on his wife and that there was a lot of problems with her. I just couldn't tell from listening to the tape. I did not draw any kind of inference that was discussed. What limited discussion there was in the tape referred to the Calabasas burglaries. But I think there's an additional inquiry that the defense must request of the court, and that concerns the scope of the allowable information that the prosecution could go into concerning this incident. Can they talk about the facts of it? Can they talk about the details about it? Can they talk about there was a conviction? Can they talk about how much money was taken? There has to be some point at which, even a case where these things are allowed, they're very limited in scope as to it relates to the relevance that the court finds the evidence has. He's absolutely right. And before I can proceed with Mr. Menendez in bringing it out, I am objecting not only to the introduction of the evidence, but I am objecting to the scope of this particular evidence as being as limited as possible to the purpose for which the court finds it relevant. The court says, all right, let me finish off with my remarks in relationship to Lyle Menendez at this point. There has been reference made to the fact that Erik Menendez is not just a witness for wait, that Erik Menendez is not just a witness for Erik Menendez, but is a witness for Lyle Menendez as well. That's been stated by the defense for Lyle Menendez. It seems to me that the probative, and he has been testifying about the relationship of Lyle Menendez to his father and not just of Erik Menendez to his father. It's been related primarily to drawing distinctions between the two, but by drawing those distinctions, it has set forth the relationship and motivations of one individual in view of the other. So again, it seems to me that the probative value of the evidence as to Lyle Menendez subsequently outweighs any potential prejudice as well, and that reference, the fact that he is making reference on the tape to that particular incident and Mr. Levin's inquiry as to what it was that Lyle Menendez meant by that, that's certainly an appropriate inquiry to be made of Erik Menendez, whether it's done by you or by the prosecutor. That's for you to decide. But I think the probative value of the evidence explaining the relationships and the nature of Lyle Menendez's relationship with Oziel as well, the probative value substantially outweighs any potential prejudice. As far as the scope of the inquiry into the burglaries, that was discussed several times during the first trial. At one point, there was a stipulation arrived at by counsel. I don't have a clear recollection of the specifics of that stipulation, but there was as such. It's in the record. I suppose you have it if you want to bring that to my attention and refresh my recollection as to what it was that was brought out in the first proceedings as to whether or not that should again be the guidelines for the evidence. Mr. Gessler. Mr. Gessler says, I'm not asking what the court's done for me in the last 5 minutes, 10 minutes is good enough. Court says, okay. But this is a very important issue. The court says, yes, certainly. Gessler says, I don't want to beat it to death, but the court mentioned that in the trial the burglary evidence did come in. That is true, but my recollection is in the first trial it came in before Erik's jury only and very late in the proceeding, and I believe it came into Lyle's jury only after Dr. Conti testified or as he was on the stand. The court says, yes, I recall that. Mr. Gessler says, in the first trial, up to that point, Lyle Menendez's objection before his jury to the burglary evidence had been sustained. I realize this is this trial. That was then, and this is now, but it does show the flexibility that can be afforded to the prosecution when you have two trials when they want to get certain evidence in without hurting the second defendant. Given the court's ruling, I then renew my motion for a severance for Lyle Menendez for a separate jury trial in which evidence will not come forward based upon Bruton, the the Sixth Amendment, the Eighth Amendment, and the 14th Amendment rights, as well as state law, Oranda, and so forth. That although it's not a statement necessarily of another defendant, the same due process rules, I think, as the court has said, apply when we have a joint trial over our own objection. So now we're seeing there is an issue here with the evidence coming in as a joint trial where normally, or if it had been a separate trial, it wouldn't come in to the Lyle side or whatever. They would make sure that it only gets to the right jury. So he makes a great point. And now the first trial we had two juries, and whenever something was not for the Lyle jury, they would send the Lyle jury out and continue testimony, and vice versa. When it wasn't for Erik, they would send their jury out. So same thing kind of applies here, except or that's what he's arguing, except in this trial there's only one jury for the both of them. So they can't unhear something for one person and not the other. And that's the problem that we're facing right now. And secondly, if any such evidence is going to come in, I would ask time that we can find that stipulation and look at that as to whether it certainly would not take away my motion or anything I've said under 352. But if damage is going to come, hopefully obviate the damage to the extent that we can. The court says, I don't think it was offered as to your client. I think it was only offered as to your co-defendant. Miss Abramson says, I don't think so. I have found it. Mr. Gessler says, I'd also ask that a limiting instruction be devised as to how the evidence is coming in whatever form it does come in. The court says, I'd certainly be more than happy to do that. I don't recall if we did that in the first trial, if there was a limiting instruction, quite frankly. Abramson says, two different juries, it doesn't matter. The court says it still would be a limiting instruction as to its use by the jury, though I don't recall if there was or not. We can review the instructions. What is the people's position as to how far you can explore this burglary issue since the facts of the burglary and the details of it aren't significant only as it relates to the relationship or as to Oziel and his participation in the whole thing? Mr. Khan says, I wasn't necessarily intending to get into all of the details. I wasn't intending to get into itemization of the loss of each burglary. However, I think that the nature of the inquiry is going to be dependent somewhat upon the cross-examination and the answers given by the defendant concerning the nature of the incident. We know now that the defendant was trying to minimize this incident in front of his jury, and he was trying to make it seem as if it was really because I was playing such bad tennis that my father was going to disinherit me. That is what he had testified to here in court. Maybe that's what he thought. Maybe he didn't know, and that's what he thought. So I think that the fact that there was such a loss as was involved in this case, and the fact that there was an arrest and the prosecution for these incidents is something that must be brought out to the jury so that these get a sense of the significance of the incident. Court says, I think all that was part of the stipulation, if I'm not mistaken, as to the amount of loss and the type of property taken, and that there was an adjudication. Ms. Abramson says, there was, Judge. The court says, or a juvenile court proceeding. It's my recollection there was. I'll let you find it and we can resume this at 1:30. Mr. Khan says, okay. Court says, but my recollection is that we went through all of this in the first trial and finally worked it out to the point of a stipulation as to what the facts were that could be brought before the jury. In regards to Mr. Gessler's remarks as far as the timing of things in the first trial and why the trial would be different than the first trial, again, I hearken back to my early remarks that this case is different because the December 11th tape is part of the evidence offered at the early stage of the prosecution rather than being introduced only after the defense had rested in the first trial or almost at the time that they rested when the defense offered it. Mr. Gessler says, one further thing. I do need a ruling on my severance motion under the state and federal constitution. The court says that motion is denied. Thank you, Your Honor, says Mr. Gessler. The court says, I just want to let the jury go if they're ready. Ms. Abramson says, there was some discussion at the last trial about getting into specifics after we had a stipulation without having read all the stuff. The court says, let's first find the stipulation. Miss Abramson says, volume 103, October 8, 1993, somewhere in the zone of 17190 on, I think we have a long drawn out haggle about it. The court says there was actually a stipulation. Ms. Abramson says the stipulation was earlier. This is coming up just as this is now, just before the cross-examination by Mr. Kuriyama. And we were talking about whether they could get into specifics, and there's some quotations here from the stipulation, but the whole thing isn't laid out here. The court says, I thought the stipulation came in later after he testified. No, says Miss Abramson. I think it came in earlier before he testified, so I'm trying. Mr. Kuriyama reads part of the stipulation to my client when he's on the stand. But it seems to me we might have marked it as an exhibit. The bailiff says the jury's coming through. The court says, do the people have any reference to that? Ms. Nahara says, no, Your Honor, where it was discussed, and that was in volume 108, the actual stipulation, the discussion of that was. Miss Abramson says, when was it read on the record? That's the question, says Ms. Nahara. Mr. Khan says, we will look for it during the noon hour. Court says, I don't think this is an exhibit. I would be surprised if it was. Let's take our recess. And they do. We're going to continue on for a little bit. All right, so they take their lunch, their noon break, and now we're back. Court says, okay, we're back without the jury. Are you ready to continue? Mr. Levin says, yes, Your Honor. We have located the stipulation that we had entered into evidence in the previous trial. It appears at volume 69, pages 11138 to 11139. I believe we can spring loose an extra copy for the court. And based on the court's ruling over our objection, we would ask that this stipulation at an appropriate time be read to the jury. Mr. Khan says, I don't know why counsel is asking that the stipulation be read to the jury when I just advised counsel 2 minutes ago that we don't care to enter into this stipulation. The problem with the stipulation. The court says, let me first read it so I can remember exactly what it said. He reads it. He says, okay. Mr. Khan says, yes, we don't care to enter into this stipulation because the stipulation doesn't even make reference to the fact that it's a residential burglary. Even Erik Menendez, in his testimony on cross-examination, repeatedly referred to the incident as a residential burglary. I think if there is going to be a stipulation, the stipulation should include the fact that the defendant was prosecuted. Of course, there's no reference to a prosecution in the stipulation either. So I think if a stipulation is to be worked out, the stipulation would necessarily have to entail something concerning the fact that he was prosecuted for 2 residential burglaries and that the adjudications were sustained concerning those prosecutions. Mr. Levin says, Your Honor, we are asking the court to limit the scope with respect to the introduction of the evidence to the most minimal amount of detail with respect to the offer of proof made by the people, and we believe the information contained in the stipulation is broad enough to go along with that offer of proof made by Mr. Khan to go any further would be improper. Attorneys Abramson and Levin confer. Mr. Levin says, and with respect to the prosecution that the juvenile adjudication was sustained at some point, it's irrelevant. It can't be used as a prior felony conviction in any event and serves nothing with respect to the stated offer of proof by the people. So we ask that the people be limited. If the people do not want to enter into the precise stipulation that they entered into it in the previous trial, that they be limited in scope to the precise information as detailed in the stipulation. Mr. Khan says whether or not it can be used as a prior felony conviction is neither here nor there. The issue that we are concerned with is the nature of the offense committed by the defendant and the impact that it had upon his father, his relationship with his father, and whether or not his father was inclined to disinherit him as a result of this embarrassing incident. On the one hand, the defense talks about how the family was so preoccupied with image and how testimony concerning their preoccupation with image and matters that would affect the family image is something that must be brought out. On the other hand, when here we have what is clearly a finding of guilt, however you want to call it, whether it's in adult court or whether it's in juvenile court, it is still a finding of guilt for two very serious offenses. Two residential burglaries. Not only doesn't the stipulation contain a reference to the fact that there was an adjudication against him, not only doesn't it contain the fact that these are residential burglaries that we are talking about, but it doesn't even have any reference to the value of the property involved. So all of these are matters that go to the significance of the incident, and I think that it's important to give the jury some sense, just some idea of the significance of the idea. And this particular stipulation does just the contrary. This stipulation minimizes the incident and distorts it. Miss Abramson says, Your Honor, Mr. Levin is deferring to me to respond since I have a better command of the facts of this case. Apparently, the people don't have the juvenile file to prove anything up here because then Mr. Khan would know that he is misspeaking about what happened there. What was eventually filed, I believe, or what Mr. Menendez admitted to in a negotiated disposition was one count of burglary and one count of grand theft. The court may recall the first of these so-called burglaries wasn't a burglary, it was a grand theft since he was already inside the premises sleeping over at the List home when he and Craig Signorelli together found the same combination, together opened the safe and together split the proceeds. And it was resolved under 654 of the Welfare and Institutions Code, which is a summary of a 6-month summary type probation by way of a disposition that actually Charles English worked out for him so that they weren't first degree burglary convictions under the juvenile code of 601. I think the welfare and institutions code, one of them wasn't even a burglary, it was a grand theft. I believe this indicates that the parents had to make restitution, and I believe we did litigate the first time around under a 352 analysis the amount taken, given the fact that the amount taken, that much of it was returned even before the defendants were accused or suspected of the thefts. There was testimony, and it was verified in the police reports of the sheriff's department that jewelry had been put back, and the jewelry from the second event was commingled with jewelry from the first event, and that's how the police knew they were linked. Oops. And if they want to talk about the total amount of the value of the property, these were claims made by theft victims, never substantiated. The property was returned. I think there was a restitution cash payment for some property that had either been lost or the stuff, for example, that was given to the court says restitution isn't the issue. The issue is how much was taken, not so much. Miss Abramson says the fact is how much was taken. It's not as if it was taken in cash. Things were taken, the value of which was never really judicially determined since it was returned. The court says, right, we don't have to be precise, but some approximation by the victims as to how much was taken. That's absurd. Why is that relevant? Says Ms. Abramson. The court says to indicate this was not just a juvenile prank. This was a serious theft of people's belongings. Ms. Abramson says, well, we said numerous articles were taken. That's in there. And Erik Menendez is going to testify that jewelry was taken and then returned so that we're not talking about little things. It's just a dollar value. First of all, it's not, we don't agree to it. We don't know what it really was. It's never been litigated. We know how much was paid because cash was taken and the cash was spent by Mrs. Menendez, spent by Craig Signorelli, spent presumably by Lyle Menendez. So there was a restitution payment to equalize that, but I don't think it's appropriate to get into all of these details or else we're litigating the value of this property. The court says, believe me, I don't want to get into the litigation of these other crimes as to what actually happened, how it happened, and how much was taken in detail. But there is, once the court has made its ruling that this is admissible evidence, there's a need to deal with it in some way that is fair for both sides. The purpose of the stipulation was so that the facts would be presented to the jury without the need for witnesses to be brought in to testify about that would about what would amount to testimony about other crimes, which wasn't necessary. So if this can be refined in some way to satisfy both sides, that would be satisfactory to the court. The fact that the prosecutors in the first trial agreed to this particular language doesn't mean that these prosecutors have to agree to the exact same language. The general nature of this sets forth the facts as they occurred and as it were known and provable by the prosecution. That's why the prosecution agreed to the stipulation. They were bound by certain limitations on their proof anyway, as far as what they could prove. Ms. Abramson says, I think this shows, Your Honor. The court says, as far as the juvenile proceeding, as to the ultimate resolution of it, I don't think that's significant, but the fact that it didn't result in a juvenile court proceeding can be brought out. Now, as far as how it was resolved, I don't think that's relevant or probative as anything, but the fact that there was such. Ms. Abramson says, Judge, in answer, the court was thinking exactly the same way, apparently, in the first trial about indicating that, the fact that it was a significant amount of property, and that's why we put in what was removed. The court says, yes, I know that, to identify what the items were. I really don't think that any of the burglary stuff should come in, but here we are. Ms. Abramson says to show that it was significant, a VCR, China, combination safe, silverware, Soloflex, IBM computer. This shows it's not a teenage prank. So I don't know why the people should have a right to go into what the value of these things are. I think just reading it, you can see it's a significant burglary. The court says, yes, I don't recall how much was reported in the first list burglary. I really don't have a recollection of the amount that they reported. They indicate so much money and jewelry was taken. Ms. Abramson says, it was money and jewelry. That's what we say. The court says, they must have put in a dollar amount on it when they reported it to the police. I don't have those reports in front of me. Ms. Abramson says, I think they got everything back. Court says, we're not talking about what they got back, but what was taken. That's the starting point. So if there was a particular amount that was identified, I don't see a problem identifying it. Ms. Abramson says, well, we do. We object to the amount because the amount was never litigated. We're not going to stipulate to these inflated numbers so they can make these insurance claims. The court says, well, we can attack everybody in the world. Let's get beyond it and get this down and see if we can resolve it. I don't think it should be a big deal now to iron it out some of the details. Ms. Abramson says this says what was taken, Judge. I don't know what else to add. They want the numbers because it sounds dramatic. We don't believe the number is significant, and that's what it's coming down to. The court says, I can't answer if it's significant or not until I see what the numbers were, quite frankly. There are no numbers, sir. Ms. Abramson says, they were very high numbers. The court says, I'd have to see it and see how it's reported, if it's in the reports. I don't know if it's the people are in position to prove it right now anyway. Mr. Khan says, well, we weren't necessarily going to get into it right off the bat with this witness, but just from reviewing the reports here, I believe the loss in one was $102,000. The loss in the other was $34,000 for $136,000 total. Court says, which was which? Which are these? Again, reported amounts. Ms. Amerson says yes, and these were not what they actually were. And Mr. Khan says the Ginsburg was 34,000 and the List burglary was 102. That's the name. The List is the name of family, their last name. So that's when they say the List burglary, that's what they're referring to. Miss Abramson says, no, no way. We'd never agree to those numbers. They're completely inflated. The court says we're getting into numbers. What the court, before the subject is addressed, we should have a further hearing. But in general, the court feels that the nature of the inquiry should be confined to the contents of the stipulation. Doesn't have to be precise, doesn't have to be confined to each of these words and no others, with the expansion that it would include the fact that it did result in juvenile court proceedings involving Erik Menendez. The outcome of those proceedings are not relevant, but the nature of the material here and the stipulation, I think, is the ballpark outline of what it is that would be the subject of inquiry. And before the people bring out dollar amounts, we would have further discussion on that if they choose to do that. Mr. Khan says, well, as far as it's being residential burglaries, the court says it says residential, so it's a residential burglary. What do you want? Ms. Abramson says he wants you to take judicial notice of the penal code, Your Honor. Court says it's clear that you could refer it to either side or you could refer it as a burglary of a residence. That's what it was. Ms. Abramson says, Your Honor, just so the court knows how this is going to come about, right now with Erik Menendez, and it's another matter that needs to be dealt with. The court may recall there was a piece of the September 17th tape of Erik Menendez statements to Detective Zoller that the people edited out that we wanted put back in, and we prepared a set of transcripts of those pages that the people had removed, and those pages specifically related to the community service work that Erik Menendez did as a consequence of the juvenile proceedings. They're taking out the good stuff, of course. Court says, right. Ms. Abramson says, so we obviously are going to bring out anyway that there were juvenile proceedings and what we would propose to do with Erik Menendez now. The court says, that was part of what we had been holding off because the people wanted that in and you didn't. Ms. Abramson said, no, no, we wanted it in. The court says you didn't want the reference to the burglaries as to the genesis of the deeds. Ms. Abramson says, since the court has ruled, we're going to solve that problem now. And what Mr. Levin is going to do is go over this part of the 17th September tape with our client, ask him what this charitable work was related to. That is the community service. The court says, actually, I think I have one of the exhibits in chambers that has to do with that, the transcript. Ms. Abramson says, I have it right here, Judge, the pages of the transcript. The court says, I mean, I actually have the exhibit from the first trial that was used. Why would he have that? Ms. Amerson says, the exhibit from the first trial that was used, I don't know what the court means. The court says there was a transcript of that particular portion. Ms. Abramson says, I have it right here. The court says, I'm saying it isn't the exhibit, the actual exhibit that was referenced. Ms. Abramson says, I don't think it was separated out the first time. It was, says Ms. Nahara. The court says, it's on my desk, so I have it. Ms. Abramson says, in any event, we have it here. It's the agreed upon transcript. We just took these pages out of the agreed upon transcript and we have copies for the jury of those pages, and that's how we were going to go back into, if you will. The court says, sugarcoat it in any way you want. The court, Ms. Abramson says, thank you, Judge. He was going back into the burglaries on the September 17th tape. Mr. Levin says, Your Honor, may I have 1 minute? Court says, Yes, I'm going to get that exhibit from my chambers anyways, Mr. Gessler. Mr. Gessler says, Your Honor, as to Lyle Menendez, who I still believe is in a somewhat different position, but the court has indicated that this information concerning his participation, as I understand it, is in the second burglary, is fair game for cross-examination of Erik Menendez. The court says, I believe it could be brought out during Erik Menendez's testimony that his brother was involved. Gessler says, That's what I wanted to know. The court says, Yes. Gessler says, Because I don't want to stipulate the house away and then end up in federal court 5 years from now explaining why I did that. The court says, That's part of the court's ruling. Mr. Gessler says, All right. As to the second paragraph of this, the court says there might not be a need for a stipulation. It might come out during testimony. So at this point, I don't know if we really have to talk about the specifics of a stipulation. Mr. Gessler says, Well, my interest was in the limiting aspect to which it goes that I would like the jury to be admonished at the time that it comes up concerning my client as to the limited purpose for which it can be used. My understanding of the court's ruling is that the limited purpose is to show the relationship between Lyle Menendez and his father as it concerns the burglary, and any, I guess, clarification that might make of the Calabasas incident as reflected in the Oziel tape. I think that was, the court says, and also the relationship of your client with Oziel. With the exception, there is evidence so far that will be developed. Mr. Gessler says, as to disinheriting. Court says, well, anything that might come out during the trial of Erik Menendez regarding, I don't know what the extent of the examination will be now. As far as his relationship with Oziel, the existing relationship before October 31st, and your client's relationship with Oziel, there might be some of that brought out. I don't know. Mr. Gessler says, May I have just a moment, Your Honor? The court says yes. Yes. Mr. Gessler says, I would just ask, Your Honor, that along with that limited purpose that the court has announced that the jury be told that this is not in any way to be considered for criminal propensity. Um, I don't know if they'll know propensity, but for what's a synonym for propensity? The court says, why don't you write something out and show it to counsel and we'll discuss it again. While they're looking for the tape, you can do that, and I'm going to get that transcript. There's a pause in the proceedings, and then the court says, I have exit 131 from the first trial. Ms. Abramson says, Can I see it, Judge? The court says, So are we ready? Mr. Levin says, We're just trying to queue up the tape, Your Honor. Just one moment. Ms. Abramson says, This is the one. I see your judge, your version. That's what's different. The one from the first trial was after a ruling that Calabasas was admissible, so which has been edited out of this version because we prepared these way back before. The court says, Right. Ms. Abramson says, So. The court says, Well, I just wanted you to have it. The clerk actually should have it because it should be in her possession. Right. Why does he have exhibits in his office or his chambers about or from the first trial? That's strange. The court says, okay, Mr. Gessler is working up a modification of 2.5. At what point do you want to do that? Do you want to do it now or once you've finished and once you've had a chance to talk about it? Mr. Gessler says, I'd like to finish it and talk about it. Okay, is there any problem going ahead with the testimony now and then coming back? Mr. Gessler says, I don't think so because I don't think the stipulation will be given right off, will it? When did you plan to enter into the stipulation, Barry? That's Mr. Levin. The court says there's not going to be a stipulation. It's by testimony as I understand it. Mr. Levin says, as I understand it, the court's ruling with respect to the scope of this evidence is limited to what's contained in the stipulation, but just to add that there has been a juvenile proceeding as a result of that. The court says, with the understanding that if the people want to go into the dollar amount, we'll have further discussion of it before they do. With further understanding that the exact words of the stipulation are not the limitation of what exactly the people can say. Yes, Your Honor, says Mr. Levin. The court says, or ask about, they're not confined to the exact words. All right, then let's proceed. Ms. Abramson says, we're waiting for the tape, Your Honor. Just one moment, we're scanning it. Ms. Abramson says, I'm taking the exhibit out of the courtroom. The court says, okay, are we ready to go? Mr. Levin says, Your Honor, I just want to do a little sound check. 1 second. Mr. Levin says, it's not audible. The court says, let's just proceed then, and you can just read it. Ms. Abramson says, you can play the tape, but just read it, so the jury really knows there's a tape. Mr. Levin says, Your Honor, I'm ready, sorry. The court says, let's get the jury out, please. And the jury enters the room. So I don't think we're going to get through all of this because there's still a lot left, but I'm going to try to do my best to get through a lot of it so that in our next episode we will get through, we'll finish direct and then begin cross, I think, is where we're going to be for the next episode. So, but I wanted to get you guys further along here. So Ms. Abramson says, you can play the tape, but just read it so the jury really knows that there's a tape. Oh, I read that. Okay, sorry. So the court says the jury is back. Sorry for the delay, but there's matters that the lawyers and I had to discuss, and more likely than not, we'll be doing that again this afternoon. Hopefully not for as long of a period of time, but we might have to take another break and have some more discussions. We're ready to proceed at this point with further direct examination. Mr. Levin says, thank you, Your Honor. Your Honor, at this time, I have 2 items that I request to mark as exhibits. First is a tape. It was previously marked as Exhibit 130 in the previous trial. I ask that it be marked Exhibit 369. The court agrees. Mr. Levin says the second is a transcript of the words of that tape. It was previously marked in the first trial as Exhibit 131. I ask that it be marked as 370, and the court agrees. Direct examination continue. Mr. Menendez, did you just attempt to listen to what has been marked as Exhibit 369, a tape? Yes. Did you determine that it was difficult to discern the words? Very. Now, with respect to that particular tape, is that part of the conversation that occurred with you and the police? Is my conversation with Detective Zoller on September 17th, 1989? Yes. Would you just listen to a few of the words of the tape so that I can ask you if that's your voice, understanding it's difficult to hear? The tape is played. Mr. Levin says, Mr. Menendez, could you discern your voice on that tape? Yes. And could you hear the voice of anyone else on that tape? Detective Zoller. Now, this conversation took place during the interview with you and the police when you were in New Jersey, Cranberry, New Jersey. Yes. I want to read you a transcript of that portion of the tape and then ask you a few questions about it. Detective Linehan says, I understand you and Lyle were involved in some charity work of some sort. Menendez says, yes, that was great. Down on Venice Beach. I worked with the homeless and we did great. I wish I would have been able to work with them a lot closer. Detective Linehan says, what agency was that? Answer, St. Joseph Center. Detective, Santa Monica? Answer, yeah, it was in Santa Monica. This was something I'm going to pursue. I've been talking to a few, the priests, fathers, or reverends, or whoever I can talk to find out what I can do about helping people like that. Not that I had a plan of what I wanted to do, but from that I hear these things are too expensive. It deals with the homeless. I just want to interject here for a second. This is Erik talking about how much he wants to help other people. He got a little bit of help, or he got a little bit of exposure to charity work and really enjoyed it and wanted to do more, which doesn't surprise me why now he's leading all these different initiatives at his prison and helping other people, trying to get other people, um, what's the word? Uh, not bail. Why am I? The parole. I could not think of the word. Try to get them all parole. Continuing on, the detective says, yeah. Answer, and that's something that I wanted to set up, but yeah. Detective, and how did that develop? The charity work. Was it because of the Calabasas thing? Erik Menendez. Ah, it was. It was because of the Calabasas thing, but my lawyer suggested and soon, but that was the reason. But it was just you ever helped people like that before? Detective says, just in what we do, and Answer, yeah, yeah, I know. I know what you're saying. Detective, although it seems like we may be on the other side, we do help them. Erik Menendez, no, no. Detective, quite a few times. Erik Menendez says, yeah, but people that are really needy. Detective says, yeah. Erik Menendez says, I never felt like that. Ah, it's amazing. It's amazing how it goes to your heart. Detective says, yeah. Eric says, to see people like that. And so, I mean, any people that I see, I was friends. I don't know. When I was young, I used to love everything. I couldn't break a branch off of a tree, a leaf off of a tree, or something. I used to love everything. I wouldn't want to hurt anything. And it seems as one gets older, they have to experience things and life is colder. But helping people like that, it just Mr. Menendez, is that an accurate recounting of that portion of the conversation that you had with Detective Zoller on the 17th of September 1989? Yes. Now, what were you referring to when you told him that you were young, uh, that that when you were young, sorry. What were you referring to when you told him that when you were young, you used to love everything? Just how much I enjoyed living when I was outside the home and I got to play in nature and the grass and the trees, and it seemed like a very innocent time. What did you mean by it, that you used to love it? I was just talking about as you grow up in life, and childhood is often very rough, and you experience things and you learn things that are painful, and that you have to adapt, and I guess learn to live with it, and it makes you a colder person than you were when you were a child. When you had mentioned to him that you couldn't break a branch off of a tree, a leaf off of a tree or something, you wouldn't want to hurt anything. What were you talking about? Just nature. I love nature and just I enjoyed being with nature. Now you indicated that there was some reference in this on the Calabasas thing. Do you recall that? Yes. Hold on, I gotta get the charger. Whoops, I wasn't plugged in this whole time. Oh well. And during the December 11th, 1989 conversation with Detective Zoller, there was talk about the Calabasas issue. Do you remember that? You mean Dr. Oziel? I'm sorry, Dr. Oziel. Yes, Calabasas issue is mentioned 3 times or 4 times. Now, were there two things that occurred in Calabasas when you lived there of significance? Yes. And was one of the incidents that you testified to where you were beaten up by a gang? Yes. Was there another thing where you did something really wrong? The burglaries. And when did you commit the burglaries? The summer of '88. How many burglaries were there? 2. As to the first burglary, did you commit that by yourself? No. Who were you with? Craig Signorelli. Who is Craig Signorelli? He is a friend of mine, or was a friend of mine. And what did you and your friend do with respect to strike that? Did you, with your friend, were you at another friend's house? Yes. And who was that other friend you were at? Whose house? John List. And while inside your friend's house, did you and Craig Signorelli take some things? We were looking for something, found something else, which led us to what we were talking about. What was it that you took from that house? What kinds of things? Jewelry, cash. Did you later tell your brother Lyle Menendez? Yes. And did you commit a second burglary? Yes. With whom did you commit the second burglary? My brother. And whose location did you burglarize? the home of the Ginsburgs. What did you take from the Ginsburgs? A Soloflex machine. Aren't those things huge? The Soloflex machine, a computer, a safe, plates, cups, some jewelry. There's other things that are mentioned I no longer remember. Did you ever spend any of the money that you stole? No. Did you ever sell any of the items that you took? No. Did you return the items that you took in some fashion? Everything was returned. And how was it returned? I turned myself into the police, and a U-Haul truck which was brought, everything was brought back. Did you attempt to return some of the property directly to the home that you had taken it from? After we took the stuff, we wanted to return it, and there was a lot of pressures in terms of that there had been before it had been found out my brother wasn't involved in the first burglary, and by accident, what jewelry from the second house back into the oh he brought so Lyle wasn't part of the crime, so he inadvertently brought jewelry from the first house to back to the second house into the safe of the first house, not realizing that it was the wrong jewelry and put it back into the safe. So when they got home, they found out that there was different jewelry in the safe than had been there when they left. And the two incidences were then connected and it became an even larger problem. After you turned yourself in to the police, were you a juvenile at the time? Yes. How old were you? I was 17. And when did these burglaries occur? July of 1988. 1 year before the death of your parents? Yes. So after you turned yourself in, was there a requirement for you to appear before some sort of juvenile court? Yes. And did you admit that you were guilty of those offenses in some fashion? Yes. And as a result of that, did you go to jail? No. Did they send you to a juvenile detention home of some sort? No. Did you do some charity work? I was put on 6 months probation. I was doing charity work, yes. And is that the charity work that you're referring to when you talked about the homeless to Detective Zoller? Yes. Did you do everything that was required of you by the court with regard to this particular case? Yes. And did you talk to Detective Zoller on the 17th of September 1989 about the disposition of the burglaries? Yes. He was aware of them? Yes. Did you talk to Dr. Oziel at any time about those burglaries? When we were, excuse me, Your Honor, can I have a moment? Says Miss Abramson. The court says yes. Ms. Abramson and Levin confer. Mr. Levin says, strike that. The court says, wait. Did you want to retract the question? What was the question? Did you talk to Dr. Oziel about any of the burglaries? Yeah, that's a bad question. The court says, wait, did you want to retract the question? Mr. Levin says, yes, I do, Your Honor. The court says, all right, the answer and the question are stricken. Mr. Levin says, did you at some point in time see Dr. Oziel as a result of these burglaries? Yes. And is that what Dr. Oziel was talking about on the December 11th or during this December 11th, 1989 conversation? Was he talking about when he said the Calabasas thing, or I won't, I don't want to right now identify who was talking, but there was the Calabasas thing brought up, the Calabasas issue. Is that what was being talked about in the conversation? Yes. Now, on December 11th, 1989, was Dr. Oziel talking about your father's reaction to you being involved in the Calabasas thefts? My brother, excuse me, my brother and Dr. Oziel were discussing it back and forth. What was your father's reaction with respect to those thefts? He was upset in terms of how it came to result. He felt that we didn't do well enough. He was angry that emotions got involved and that something was returned, in which case A suspension came to me, and I admitted he was very angry about the way it happened, and not so much the way it happened, but just that we didn't do it well enough to where we got caught. And as a result of getting caught, there might be a scandal and it could taint his political image. Was your father, or did your father ever express any anger with you over the fact that you had committed these thefts? The way in which they were committed in terms of getting caught. It was always expressed to you his dissatisfaction was in the way you were because you got caught, because of the results that would happen since we got caught. Was he ever upset in any way regarding the morality of stealing? No. Was that inconsistent with your father's views concerning stealing and lying and cheating? No. Had you been brought up to in such a manner that cheating was part of your upbringing by your father? Cheating, stealing, he was talking about on the tennis court or on business with people. Anything that you must do to succeed is justifiable in his eyes. Did your father teach you how to cheat at tennis? Yes. And how? What is your earliest memory of your father teaching you how to cheat at tennis? Objection, irrelevant. Well, I'll overrule it on relevancy grounds, but let's see if you can make it rather brief. Mr. Levin says, I will, Your Honor. Court says, okay, overruled. The witness says, he would give us hand signals in the when I played tennis to where if he felt that a ball that the opponent called out was in, or he felt that it was an important point that I needed to win it, he would give me a signal, and that meant that I was supposed to call a ball at an opportune time at an important point that landed in the middle of the court where it was obvious. I was supposed to call that ball out so that the player would basically go crazy, knowing that the ball was obviously in and it would mentally destroy the player and at the same time as winning the point. These are the things that would happen. So, psychological warfare was what Jose was all about when it came to your opponent in business or on the tennis court or anywhere else. Weren't there line judges or referees or whatever you call them, people you would be that who would be referencing the match? The honor system was used as a juvenile player. So there was no one like a referee at the tennis court. There was the tournament umpire in which if he felt somebody was cheating, you could request for a lines person, but usually not. Where would your father be when he would give you these signals? Objection irrelevant. Overruled. He would be at strategic points. He would walk around or be in the balconies so that I could always see him. And these signals that he would give you were these signals that he gave you in tennis throughout your tennis life, throughout your career as a tennis player? Yes. And it went from your early years throughout to your teenage years? Yes. What kind of hand signals did he have? Can you show us? Objection irrelevant. The court says, okay, as I said, let's make it brief here on this subject. Do you need some water or do you have it? Ms. Abramson says, I need a moment, Your Honor. They confer. Mr. Levin says, did your father have anything to do with your schoolwork? Yes. Did your mother have anything to do with your schoolwork? Yes. Did your mother have anything to do with your cheating? Objection irrelevant. At schoolwork? Objection irrelevant. Overruled. The witness says yes. How did your mother, in what way did she involve herself in you cheating in your schoolwork? Objection irrelevant. Overruled. She felt that the grades were more important than the information, and so if I wasn't able to do an assignment right, and after being out of the closet, remember that was punishment, couldn't still do it right. Finally, in the end, she'd do it for me, or if I was able to get a test from one of the other kids that we were going to take, she would do the test for me. Unbelievable. Mr. Levin says, how about your father? Did your father have anything to do with your cheating at schoolwork? Worked in the same way. Did your mother ever assist you in getting a phony identification card? Yes. Was it a California ID? Yes. And how did she do that? She fidgeted with the numbers and Xeroxed it in a way where it changed the card. Was there was it ever brought to your attention, Mr. Menendez, that your school work that you turned in was different than the type of work that you did in class? Objection, irrelevant, sustained. Mr. Levin says, was it ever brought to your attention by any of your teachers that they were aware that your mother and father were doing your schoolwork? Objection, irrelevant, sustained. The answer is stricken. There was no answer, but okay. I guess we can't say that the parents did their schoolwork. Were there times when your mother had talked to any of your teachers concerning your schoolwork? Objection, irrelevant, sustained. With respect, with the things that you had taken into these thefts, you indicated that you took some money? Yes. What did you do with the money? A portion of the money that we thought we had taken from the safe was returned. The other money my mother and my father found, which is how it all unfolded. And when this money was found, what happened to it? It was spent. Who spent it? My mother. Mr. Levin says, if I could have just another moment. The court says sure. He confers with Ms. Levin. Mr. Levin confers with Ms. Abramson, and now Mr. Levin asks, Mr. Menendez, despite the fact that your father encouraged you to cheat during tennis, did you want to? No. How did you feel about having to follow your father's hand signals and cheat at tennis? Objection, irrelevant, overruled. The witness says, because you'd have to call the ball out in an obvious way, there were often 50 to 100. Objection, non-responsive, says Mr. Khan. The court says sustained. The answer stricken. Mr. Levin says, how did you feel? I was embarrassed. Before, when you related incidents concerning your father's reaction to you not following hand signals, were these the hand signals that we're talking about? Yes. Mr. Levin says, thank you, Your Honor. I have nothing further. And Mr. Gessler says, thank you, Your Honor. So Mr. Gessler, this is not cross-examination. This is examination. This is direct examination. But it is, I guess it's considered cross because it's not his defendant, maybe? I don't know. Is it considered cross if they're co-defendants? I wouldn't think so. Anyways, we're going to stop here. Excuse me, I'm losing my voice, so that's another reason why I want to stop here. So we'll stop here. We'll continue with the whatever examination, whether it's cross or direct examination by Lyle's attorneys of Erik Menendez next. And then that'll catapult us into cross examination. So we will, in the next episode, I am sure of it, at least finish direct, if not begin cross. So that is all I have for you today. Let me know in the comments below if there's other cases that you'd like to follow or another suggested transcript that we could read through when we're done with Menendez, because I'm interested in what you guys are interested in. So let me know in the comments below. And I will see you guys in the next one. Take care. Bye, guys. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.